All right, this next document is 67 pages. It's a lot of writing on every single page. Also, it's in only have it electronically, not in paper format. It's very small. So I'm going to do my best to put my glasses on and read it. And here's what Schaeffer has to say about it. He says, the following is the prosecution's sentencing memo. It's all lies. Yet it has some very honest sections when Scrocky goes on a Nazi rant about how Cox has personal beliefs that the feds can't stand. He attacks Cox's ideas and in so doing reveals with great clarity the government's true motivation behind these trumped up charges. Also watch for accusational confessions. This is a shockingly strong pattern throughout. The feds do something horrible, then turn around and accuse an innocent party of the very thing the feds themselves just did. Once you start looking, you'll see it all over. Accusational confessions. What did feds do? They attacked women and children. They made lists of people to get rid of. They plotted murder. They think they are above the law. They lied to the jury. They are master manipulators. They have no empathy. They are dangerous. Cox is none of those things, but he's accused of it. All right, page 1. Karen Loeffler, United States Attorney. Stephen E. Scrocky, Yvonne Lamoureux, Assistant U.S. Attorneys. Summary of sentencing recommendations. Term of imprisonment, 420 months, 35 years. Supervised release, 5 years. Special assessment, $900. Okay, page 2. Forfeiture, 22 pistol and silencer, grenade parts, Sten machine gun, 37 millimeter launcher, and Hornet's Nest anti-personnel rounds. Not contested. Fine, not requested. The United States Probation Office has prepared an extensive pre-sentence investigation report in this case. The United States does not dispute the factual findings or legal conclusions of the PSR and hereby incorporates the findings of fact and the conclusions of the PSR herein. It's the government's position that there exists sufficient and in many instances overwhelming evidence to support the factual findings of the PSR given the vast amounts of evidence admitted during trial, the guilty verdicts returned by the jury and other evidence relied upon by the pre-sentence report writer. Number 2, background and counts of conviction. Defendant Schaeffer Cox was charged with co-defendants Barney and Vernon in a 16-count indictment for a variety of federal crimes. These included but were not limited to conspiracy to murder federal officials, solicitation of a crime of violence, murder, possession of unregistered destructive devices, and conspiracy to possess unregistered silencers and destructive devices. The trial was footnote number 1. The PSR appropriately includes a number of facts regarding Cox's co-defendants Barney and Vernon and actions they took during the course of the conspiracy. The government sets forth below a summary of meetings where Cox was present and participated. However, the government agrees that it is proper for the court to take into account Cox's co-conspirators' actions at Cox's sentencing. Page 3. The trial was held between May the 7th, 2012 and June the 18th of 2012. Approximately 80 witnesses testified during the course of the trial. Despite the length of the trial, the amount of evidence, the large number of witnesses, and the number of charges, jury deliberations were relatively brief, which is a comment on the strength of the government's case. From 2009 up to his arrest in March of 2011, Cox created, organized, and ran a number of political and/or activist groups in Fairbanks, Alaska area. These groups included the Alaska Peacemakers Militia, the Second Amendment Task Force, and the Liberty Bell Network. Cox was also involved in the Alaska Assembly Post, an alternative government association where Cox was bestowed the title of Secretary of Defense, as well as holder of the office of Commander-in-Chief of the several states of the United States of America. PSR paragraph 21, with the exception of the Alaska Assembly Post, these groups were organized by Cox and to a large extent used by him to further his personal and political goals of challenging the existing governmental and judicial structure of the state of Alaska on several fronts, including a campaign to discredit the judiciary by claims of fraud and lack of any jurisdiction, and to challenge the court's authority over him with respect to his own criminal cases. PSR 49 through 50. In furthering this attack on the state's legal and law enforcement institutions, Cox went on the lecture circuit in several states, grandiosely claiming strategic successes based upon the page 4 supposed strength of his groups in conflicts with the existing governmental structure. At the same time, Cox lectured crowds or gave interviews about his concepts of liberty and the right to bear arms vis-a-vis government regulation. During the speeches, Cox expressed a clear message that meeting government force with force of a militia was the only way to prevail against his perceived view of government tyranny. That is a complete lie. PSR 26 and 52. On several occasions, he claimed no hesitation in killing law enforcement officers who aggrieved him or who were his neighbors. That's a lie too. Cox's meetings with his inner circle, however, were far from the purely political speech. Given his increasing brushes with the law in 2010, Cox used the threat of his malicious power and loyalty to him to threaten and intimidate the judiciary and members of law enforcement. Cox's threats went from the subtle, like visiting R.W. at his home on a weekend under the cover of peace, to the overt, direct threats to state court judges or Alaska state troopers of the malicious power, numbers, intentions, and desire to stand up for Cox in the event of his arrest, none of which he claimed he could prevent or forestall. These actions wherein he used the threat of his militia or threats of violence by them to insulate himself against the criminal justice system were the first, not so tentative steps in Cox's plan of instituting his own form of government. And what form did this government take? Cox's form of government included his own judiciary, his own military, and his own law enforcement arm, the APM and Cox's County Rangers. Footnote 2, Cox even took the step of purchasing police duty belts, replete with 6 sets of conventional handcuffs and 6 sets of thumb cuffs. Cox, however, would not and did not wait for the electorate to vote on implementing these changes as free exercise of a public vote on the Cox form of sovereignty, as this was not something Cox was interested in pushing. He had apparently had enough of the voting process when he lost his first and only foray into the political arena. His sovereignty movement, therefore, was based on some undefined philosophy of peaceful coexistence between the Cox system of government and the one in place. It was not a mutually agreeable coexistence inasmuch as Cox espoused the belief that he was not subject to man's law. With respect to 12, conspiracy to murder federal officials, and count 16, solicitation to commit a crime of violence, PSR 40, Cox's journey began in 2009. During the fall of that year, Cox and Michael Anderson met and discussed what would happen if the government declared martial law. Cox and Anderson agreed that those in position of government leadership would have to be killed before they got to us. It was during one of these conversations that Cox and Anderson agreed to the creation of a targeting list, which would contain the names of officials who would be killed when martial law took effect, PSR 25. During the course of this investigation, Cox referred to the existence of a list and Anderson's connection with it several times. Anderson testified about the list during trial, as well as his own attempts at creating a federal hit list. Physical evidence of this plot was located during a search of Anderson's home in the form of a hand-drawn map of the Fairbanks Federal Building along with the names of federal officials. Anderson testified that Cox provided the names that he, Anderson, wrote down in a meeting with Cox at the IACC Coalition in 2010. Cox has, at trial and with respect to the pre-sentence report, denied providing Anderson with the names on the list. Cox's claims are simply not credible. This is especially true given that Anderson would have no way of knowing TB, TS, or NC who were officers and employees of the Transportation Security Administration and the Department of Homeland Security Customs and Border Protection. See Exhibit 504-009, Target List, PSR 27 through 30 and 48. Footnote 3. In fact, Anderson testified that Cox had him locate OCS employee WW, which Anderson ultimately did. See Exhibit 194, pages 41 through 43, and Exhibit 518. Documents regarding WW, Exhibit 518, was located in Anderson's truck. There is no conceivable reason why Anderson would have this information other than through Cox's direction. The jury also heard testimony from RW, TB, that's Ron Wall, Trina Bucamp, MJ, WW, NC, and DB regarding their interactions with Cox and their lack of interactions with Anderson. This testimony corroborated Anderson's testimony. Where was I at? I'm looking for footnote 3. Hold on. Cox directed Anderson to compile information regarding not only those federal officers, but also officers on the United States Marshal Service and, going on to page 7, and officers of the state of Alaska, including Alaska State Troopers and Office of Children's Services. Footnote 4. For example, Cox asked Anderson to get specific information on Alaska State Trooper RWBB and MJ. WW, I think, is Wendy Williams. PSR 37, Trooper MJ information later was provided to Olson from Cox on a post-it note. Anderson also testified that on March of 2010, after Cox had been charged with assaulting his spouse, that Cox asked Anderson to remove certain items from his home. At trial, Anderson testified to observing a silencer, the Sten machine gun, which Cox previously told Anderson was fully automatic, and several grenade holes, PSR 30. These items were possessed by Cox for a full year and probably, hold on just a second. Okay. And probably more before the arrest search warrants of March 10, 2011. Cox's personal stash of illicit weaponry wasn't enough to turn the ship of state off its present course. To do that, Cox needed numbers and to increase perceived membership in the militia so that the government and to those he spoke would take him seriously. Cox inflated his membership, but also he held gatherings to increase the militia's members. In August of 2010, Cox held a militia commissioning ceremony at Barney's residence. At that meeting, Cox told the attendees that there was a federal assassination team out for him and his family. Exhibit page 100-02, footnote 5. Footnote 5 says, unless otherwise noted, the exhibit number refers to the trial exhibit previously admitted in this matter. Citations to recordings played at trial also include the corresponding transcript page number. Cox also described his version of his dispute with OCS. He accused the federal government of being behind the OCS investigation and boasted he told a state court judge, we don't mean any harm to anyone, but if you want a war, we've got one hell of a war with your name on it. Exhibit 1, page 110. November 2010, Cox took a step of having a security detail available to protect him, his wife, common law judge Bartell, from the supposed federal assassin team. This armed body armor attired security detail was scheduled to protect Cox while Cox attended a proceeding in downtown Fairbanks at the Rabanowitz courthouse on a misdemeanor weapons charge. Another detail was planned for later that evening while Cox was at an interview at KJNP television station. Both details received instructions to shoot to kill if plainclothes agents drew down on Cox or one of the other protectees. How the members of the security detail, none of whom had any weapons or security training, were to differentiate between local, state, federal, or simply citizenry, the drawdown phase was never explained. Cox held several meetings to organize the security teams for his court appearance and KJNP appearance. A whiteboard displaying the plans was seized during the search of Cox's residence. Exhibit 148 PSR 42. Notes regarding the security detail plans were also found during the search of Cox's, Barney, and Vernon's residence. Exhibit 153, 203, 446. During one of the pre-security detail briefings, Cox instructed his men that they had to be prepared to kill federal agents. and described a scenario where they would stomp the killed federal agents through the ice. PSR 40. Cox called the federal agents soulless assassins and said if we kill one of them, they're not going to be missed. They're not going to come looking for you. Exhibit 303, page 48 and 49. Cox also said that he had bought a whole bunch of Hornets' nest grenades to be loaded into grenade launchers, which Cox could provide to the men, and attach 2 grenade launchers to their rifle. Exhibit 3-03, page 50. Barney was in charge of the security detail at KJNP, PSR 35, 35A, 36. Barney was armed that night with a 37mm launcher loaded with a Hornet's Nest round attached to his AR-15. Vernon and Gary Brockman were also armed that night as part of Cox's security detail. The security detail set up lights and established a vehicular funnel point and stopped at least one incoming vehicle while visibly armed with weapons. Barney was set up on the perimeter, standing by a tree and wearing body armor. Another member was patrolling on a 4-wheeler on the property. In December of 2010, Cox, Vernon, and Barney and others continued to discuss providing armed security for Cox. Barney attempted to recruit people to be a part of Cox's security detail for Cox's state court hearings. During the course of those state court proceedings, Cox made threats to a state of Alaska judge and an Alaska state trooper. In January of 2011, Cox, Barney, and the Alaska Assembly Post organized a common law court for the purpose of trying Cox for criminal violations of Alaska, for which Cox had already been convicted and or charged by the state of Alaska. Barney recruited the jurors for the trial held at Denny's. The common law jury unanimously acquitted Cox of criminal charges. PSR 56. Cox had Vernon and Olson go to Anchorage February the 4th through 6th, 2011, to attend a convention on behalf of the Alaska Peacemaker Militia. Before Vernon and Olson left Fairbanks, Cox gave them direction regarding their trip, including to get as many pineapple grenades as you can get, because we'll just thread the bottoms and stick an ALS fuse in them. Exhibit 3-03, page 101. Cox also described how if they could get pineapple grenades with the hole in the bottom, they could tap it, put a bolt in it, put gunpowder in it, and put in a new fuse. Exhibit 303, page 105. Cox added that he already had the new fuses. ID Cox then brought up C-4 and said he knew someone who would make it for them and that he had discussed the price with him, but it would depend on the shelf life of the C4. Exhibit 3-03, page 105-106. Cox said it would be good to have C4. Vernon and Olson traveled to Anchorage and followed Cox's direction. Immediately upon meeting Bill Fulton, Vernon inquired whether he could purchase. Okay, I'm going to take a break here on the top of page 11. Taking a break at the top of page 11. Okay, I'm going to start on top of page 11 of the United States Government Sentencing Memorandum. Vernon inquired whether he could purchase grenade bodies from him. During the subsequent conversations that weekend, Vernon indicated that he wanted to purchase grenades, 50 grenade fuses, and a suppressor. On February the 12th, 2011, Cox held a meeting at Ken Thessing's residence with Barney, Thessing, and Olson. PSR 70-7173. Cox indicated that he was not going to appear for his next scheduled court date, February 14th, 2011. Cox raised the idea of a 2-for-1 plan, that if Cox or any militia members were killed, then Cox and the others would kill 2 other people, including law enforcement and judges in return. During this meeting, Cox said that 2 state court employees, Martin Guerrero and Ron Woods, needed to dangle together like wind chimes. Exhibit 1401, page 55. When Barney asked Cox whether 2-for-1 is initiated upon killing people or hauling Cox to jail, Cox responded, "I believe that it is absolutely morally allowable if they were to come and arrest Ken for the 3 of us to go kick in the judge's door and troopers and arrest 2 of them. And because it's war, it doesn't even really have to be the ones that did it. It's not just a war. In fact, it's a war declared by them explicitly without mincing any words. And so I think it's absolutely morally allowable that if they arrested Ken or arrested me, to go in and arrest 2 of them. If they kill one of us, we go kill 2 of them." Exhibit 1403, page 83 and 84. Cox continued that he would be well within my rights to go drill McConaughey in the forehead and any one of these people that are propagating this because they're posing a huge threat to my life and my family. Exhibit 14-03, page 85. Cox's reference to McConaughey was the state court judge presiding over his pending criminal case. Cox continued on, stating that he had the moral allowance to shoot them. After Olson sought clarification, Cox said, "Go for the ones that are either authorized or failed to prevent." Exhibit 1403, page 87, Cox's rationale for that statement was because then they'll give people pause to authorize or fail to prevent. ID. Cox continued, "I'd say the trooper that did it and the trooper that authorized it and the judge that authorized it. You know it. It would be kind of the two top people." Exhibit 1403, page 8788. Cox expressed that it's a tough issue because it's easier to get ready to die than it is to kill. Exhibit 1403, page 89. Cox said that he was willing to kill. Exhibit 1403, page 90. After hearing from Barney, Thessing, and Olson, and Cox summarized, "All right, let me give you guys my thoughts. I really appreciate your thoughts on that. My thoughts on 2 for 1 is that we're not in a strong enough position to execute more than once. We're not in a strong enough position to follow through. And so at this point that we should do is everything we can to avoid it, but that we should do is we should bluff it for all it's worth and pray for God's protection, shielding hand, and work and train and get ready to where we can turn that 2 for 1 into a real ability instead of just inaudible." Exhibit 1405, page 113, Cox and Barney then discussed next steps. Barney, "In the meantime, training up guys and inaudible guys through and getting them ready." Cox, so that we can turn it from a bluff to a Barney in action. "Yeah, and we'll take we're ready, and the road I'll take is we're ready, and we could have you dead in minutes, but we're long suffering and we want to be your friends. We want to stop. You've got to stop pushing. We want to be at peace. We're going to continue long suffering, but not forever." Exhibit 14-06, page 117, 118. Barney then volunteered that they should get those little target bullseye things. You put them on the back windows of all the cop cars. Exhibit 1406, page 118. Because Cox was not going to appear for his next court hearing and they anticipated that an arrest warrant would be issued, Barney offered that Cox and his family could hide out in Barney's rental cabins. Exhibit 1406, page 119 through 20. Barney also expressed concern that law enforcement may be able to locate Cox there. Exhibit 14-06, page 120. At the February 12, 2011 meeting, Cox also discussed with Barney, Thessing, and Olson the grenades he currently possessed and expressed his desire to get grenades with longer delayed fuses. Exhibit 1407, Cox said, "I would like to have 8-second fuses and powders that burns fast enough to really send that shrapnel flying because we're using the 2-second fuses right now." Example 1407, page 156. Similar to Cox's statements in February 4, 2011, it was clear at this point that Cox was in the market for more grenades. Later that same day, Cox provided Olson with Anderson's contact information so that Olson could get in touch with him regarding the list. Cox gave Olson a note with a name and home address of Alaska State Trooper MJ and indicated that MJ needed to be on the target list. Cox described him as the guy we've been having problems with. Exhibit 1603, page 29 through 30. Cox also showed Olson on a map where other Alaska State Troopers and a state court judge live, PSR 72. Barney attended Cox's state court hearing on February 14, 2011 to find out if an arrest warrant was issued for Cox. Judge McConaughey, the same McConaughey referenced by Cox at February 12, 2011 meeting, issued an arrest warrant for Cox. Cox, now a fugitive, moved into Vernon's residence. Cox, Lonnie, and Karen Vernon and Olson met at the Vernon's residence on February 14th and 15th, 2011. PSR 76, 77, 79-80. Cox and Vernon talked about ways to set up booby traps to block access to his house by law enforcement. Exhibit 18-02. Cox described his vision of the plan. Cox, "It gets bloody when we've got our crap together enough to make a good effort at round 2. Yeah, round 1 is going to be easy. Round 2 is where the work starts." Olson, "Yeah." Page 15. Cox, "And we can do round 1 right now. I think the blood starts is when we feel like it starts either just the point of total desperation when there's nothing else and it's just a Hail Mary before we get swallowed up alive, or when you've got the power to possibly prevail." Yeah, when they recognize the power. It's not like we're waiting for them to get bad enough. Example 19, page 4 and 5. Cox later summarized, "So what do? We'll kill a whole buttload of them and offer peace." Exhibit 21, page 13. On February 15, 2011, Cox and Olson discussed a variety of firearms and scopes, and Cox corrected Olson that they were probably going to be doing their battling at houses instead of in the woods. Exhibit 2205, page 152. Cox kept a number of firearms in a shed on his rental property near Bradway Road in North Pole. Barney went to the shed before the KJ&P security detail in November of 2010 to retrieve the 37mm launcher and Hornet's Nest anti-personnel rounds he carried that night. On February 14, 2011, Vernon asked Cox whether he needed anything out of that stash at the North Pole and said that Coleman called me. I've got to call him back here pretty soon. Exhibit 20-03, page 13. Cox responded that there's all kinds of goodies out there, but just leave them there. On February 19, 2011, Barney hosted a meeting with Cox, the Vernons, Thessing, Barney, and Olson. After the meeting, Cox and his family moved into Barney's home. Cox brought with him some of his firearms, his body armor, and CS grenades. Cox and his family continued to live at Barney's residence until the day of arrest, March 10, 2011. At a separate meeting later on February 19, 2011, attended by Cox, Barney, and Olson, that there was further discussion about the 2-for-1 plan, PSR 64. Cox said, because I'm not interested in go in and kill, wicked people who deserve it, and who it's definitely, if we all shook hands and went out here to go roll judges' heads, we're definitely morally justified. Exhibit 24-12, page 329, Barney agreed. Regarding 2-for-1, Cox said, but I can say that I think for right now a 2-for-1 would be running out ahead of the scale and sacrificing ourselves to no avail. Exhibit 24-12, page 336. Barney responds that he thinks that our troops, and that's the scale starting to tip, when they see more people that start to wake up and come to our aid, and even if they still have greater numbers, there'll be a point where even with the guerrilla warfare and stuff like that, 2-for-1 becomes a real possibility at that point, because you actually have enough people on your side that you can pay 2-for-1 for a while. Exhibit 24-12, page 337. Cox said that his subconscious goal was to be able to get prepared to execute a 2-for-1 that needed to be. I think that it needs three more things here. Exhibit 24-12, page 338. Cox said one thing it needs is more public pain. Exhibit 24-12, page 339. Second, Cox said we just need more numbers. Exhibit 24-12, page 340. Cox said I think 2-for-1 is two things. We've got to get ready for it, and there has to be, not for the predisposition to, well, I don't know, judgment, just a few minutes inaudible in the general. We've got to have those two things in order for it to work, in order for it to not strengthen the enemy. You've got to have the numbers to sustain it, and we've got to have the pain in the general public. Exhibit 24-12, page 340 through 41. Barney then added, and even with our guys, we've got to have the pain. And you look at our snitch to when JR contacted him, he was all big talk. Exhibit 24-12, page 341. Barney was referring to Mike Anderson and was clearly aware that Anderson had been tasked with and what he had failed to provide to them. Later in the conversation, Cox and Barney agreed that if the government took one of our kids, that's the 2-for-1, Exhibit 24-15, page 383-86. Cox later told Barney and Olson, well, I'm not going to target women and children, but I'm not opposed to killing them either. God had them kill men and women and children. Exhibit 24-16, page 391. Cox also told Barney and Olson that the purpose of killing somebody is to prevent them from killing the innocent. And I'm not against some drastic, shocking things either, like, mailing heads to people. Exhibit 24-16, page 394. Cox then said, I don't want to gloat, just make people suffer. Exhibit 24-16, page 395. Cox also told Barney and Olson, I think if you got the time and resources, you ought to give them a proper burial, Exhibit 24-17, page 398. Cox also told Barney and Olson, referring to the victims, that just for the fact that they are made in God's image, they are valuable. But that doesn't mean that I won't kill you or I won't hang your body from a lamppost to deter others. Exhibit 24-17, page 399. On February 21st, 2011, Cox, Barney, and Olson went to the property of a Bradway Road owned by Cox, where he had a shed containing weapons, PSR 65. While Cox spoke with his tenant on the property. Barney and Olson moved items from the shed into Barney's truck. The items included assault rifles, ammunition, and approximately 8 grenades. On February 22, 2011, Cox, Barney, and Olson met at Barney's residence, PSR 88. Barney relayed a conversation he had with an arms dealer and explosive dealer about a rumor 8 grenades got stolen from Fort Wainwright, and Cox got them. Exhibit 2701, page 7. Barney continued that me and Schaeffer were talking about it and thinking 8 grenades doesn't sound like a lot unless you're one of the judges or DAs we're looking at. Exhibit 2701, page 8. Barney then described a new type of body armor, dragon skin, and that he was interested in getting, and that he said you could only get it through a dealer. Exhibit 2702. Cox told Olson that he had one fully automatic weapon and that it was a weapon that he had made himself. Exhibit 2705. Cox, Barney, and Olson also discussed a communication plan, a way to avoid detection by law enforcement, of using red phones and yellow phones. Page 19. Phones to speak with each other. Cox gave Olson a list of tasks for another person. One of the tasks included picking up Cox's lower receiver, which would make one of Cox's rifles fully automatic. Exhibit 123. On February 26, 2011, Cox, Barney, and Olson met at Barney's residence, PSR 9092. Olson told Barney that Vernon was saying that you guys might be interested in some silencers, Exhibit 2801. Barney responded, oh yeah, he's the one that's getting them. Olson corrected him and said, it's actually me. Who's getting them? Olson said that he's getting them from Bill. ID Olson then told Barney that Bill Fulton is the dealer. Benedict Arnold, Bill Fulton is the dealer, but he just does it under the table, kind of makes them disappear, loses them, or however he can work his books. Exhibit 2801, page 32. Olson told Barney and Cox that Fulton is all gung-ho to come north and start the revolution. Exhibit 2801, page 35. Cox responded that we're going to have some pain to shut people up about their decadence. ID Barney added, and then that will happen is the numbers in the militia will be just enough of a force, I think, of people inaudible, those who wanted but didn't feel enough pain. Then at that point, Cox ordered a pistol and silencer match sets. Exhibit 2802, page 3738. Cox then discussed with Barney and Olson how a silencer would work with a Glock firearm. Exhibit 2802, page 38 through 40. Cox told Barney and Olson that he would love to get a centerfire silencer. Exhibit 2802, page 42. Cox also told Olson that we just did a little tutorial yesterday, homemade silencer for 22s. Exhibit 2803, Cox, Barney, and Olson talked about subsonic ammunition. Exhibit 2803, page 51. Cox agreed with Olson that his trade a C93 semi-automatic rifle with a full auto lower receiver for the pistol silencer match set. Exhibit 2804, the C93 rifle and lower receiver were with a gun shop owner, Rob Carr. Cox also described how to modify a firearm to make it fully automatic. That same day, Barney also ordered a pistol silencer match set. Exhibit 2805. Later in the conversation, Cox, Barney, and Olson discussed a missing grenade launcher. Exhibit 2807, Cox asked Olson if he had gotten a grenade launcher, but Olson said he didn't see one when they moved the firearms from the Bradway Road shed. Barney added, I know we haven't used it on any of the little missions that we've done. The only one we've used is one with the spider on it, and I've mounted it to my AR with HOV Hornet's Nest. On March the 1st, 2011, Cox, Barney, and Olson met at one of Barney's rental cabins, PSR 9394. During the conversation, Cox told Olson that he'd like to have some pineapple grenades. When they were discussing the price of grenades, Cox said, but yeah, if Bill Fulton, Benedict Arnold Bill Fulton, come down even, I'd say anything below $70, I would be willing, like I can buy as much as I want. And if he gets it at footnote 6, Barney testified at trial that he saw Cox fire his silenced pistol from Barney's office door. Okay, I'm going to stop here on the top of page 21. Stopping on the top of page 21. Okay, picking up at the top of page 21. So I think I'd stock up Exhibit 2904, page 22. When Cox asked Olson how much Fulton wants for 25 grenades, Barney said, that would be 200 cash right now. Ooh. Exhibit 2904, page 23. Barney also relayed a conversation he had with a member of his church who asked Barney, I need to know where you stand on these things because he says I don't want my family to go through Is my family in danger? Are you guys going to show up at church one time? Exhibit 2905. Cox responded to Barney, you should ask him, well, are you planning on doing that? Would make my guys show up at your house? You know, I'm the operations officer, ID. On March 4, 2011, Cox and Olson met at Barney's residence. Olson informed Cox that only 8 grenades would be available for purchase from Bill Fulton. Exhibit 3006. When Olson relayed that he told Fulton that they wanted them, Cox responded, yeah, as many more as you can get. On March 7, 2011, Cox, Barney, and Olson met at Barney's residence. Cox and Olson then went to a local gun dealer to retrieve the lower receiver, which Cox had agreed to trade for the pistol silencer match set. They obtained the lower receiver PSR 100. Cox and Olson then drove around looking for Anderson in order to obtain the list information from him, but were unsuccessful in contacting Anderson. On March the 8th, 2011, Cox and Olson spoke on the phone, and Cox relayed that he met with Anderson and was not able to get the target list information from him. Exhibit 3201. Cox described Anderson as pretty chickened out. ID. Cox said it's not like he got a monopoly or anything that can't be achieved the same way. We can get it another way. We can go about it another way. On March 9, 2011, Barney spoke on the phone with Olson. PSR 103. Olson told Barney that everything's a go and we've got that equipment in. Exhibit 35, page 3. They set a time to meet the following morning so that Barney can be there and check this stuff out and whatnot. Example 35, page 4. Olson later added, and we'll meet up with Hans, phonetic, 2 at the same time. Exhibit 35, page 5. On March 10, 2011, Cox and Olson spoke on the phone about meeting up later that day. Cox asked Olson about the guy and the canned goods and the produce, and asked Olson, you got the cans and the produce? Exhibit 37, page 3-4. Olson testified that Cox was referring to silencers and grenades. On March 10, 2011, Cox and Barney met Olson and rode with him in his vehicle to a location where they were supposed to complete the deal to buy the pistol silencer match sets and grenades. PSR 107-108. Seconds after Cox and Barney got into Olson's vehicle, Olson told them that he stashed the goodies and that Fulton got them was match sets of 22s instead of the XDs they ordered. Cox's response was, well, that's gay. I have a silenced 22. Exhibit 3801, page 5. Olson also told Cox and Barney that Fulton did have grenades and that they cost $50 each. Exhibit 3801, page 6. Olson added that the grenades are the real military legit straight from the Army. Barney responded, that's still cool. Cox, Barney, and Olson then had the following conversation about silenced 22s. Olson, because of the silencers, I guess they go inaudible. They go, these ones here will go 200 rounds, these 22s, before you have to touch anything to the oil. Well, we can go light. Olson, yeah. Go light and quiet. Well, the thing with a silencer is you're close range anyway. Barney, yeah, you know. But C-22s, even at close range, they take a long time to die. Exhibit 3802, page 2-3. Cox, Barney, and Olson then discussed subsonic ammunition, and Barney asked, how are they for devastation? Pretty good. Exhibit 3802, page 4. Barney also asked whether the silencer would go on my 57 by 28. Exhibit 3802, page 6. Cox asked Olson whether he ordered the XD .9 millimeter pistol silence matched sets, and Olson said they're 10 to 12 months out because the dealer has to lose them. Exhibit 3802, page 6. Barney responded, well, let's get them on. The Cox added, yeah, let's see if they're coming. Barney also asked if Olson could talk to Fulton about if you can get anything for the 223 as well, or 5x6. Still on the topic of silencers, Cox, Barney, and Olson had the following conversation. But in the way I look at it, for me personally, anything silent like this, I'm prepared to take it. Well, it keeps the element of surprise. Yeah. Well, the element of surprise is something in you, even if it's not a silencer, then you're going to be surprised. It's the element of escape. Olson, yeah. Barney, but how deep can you get in with the element of surprise, I should say? Yeah, because Barney, rather than there just be an initial contact, Exhibit 3802, page 7 and 8. Olson asked whether homemade ones work, and Cox asked him to clarify whether he was talking about grenades or silencers. Exhibit 3802, page 8 and 9. When Olson responded that he was asking about a silencer, Cox said that they work and they're reliable and dependable. Exhibit 3802, page 8 and 9. Regarding homemade silencers, Cox, Barney, and Olson had the following exchange. Have you seen mine? No, no, you never did show me. You were telling me. Remember, it was packed away. It's pretty quiet. Is it? Super quiet. I mean, how can you get off before you refill it? Like 2 or 3? Well, a couple of magazines, could probably do 20 rounds before you start to hear a difference. Exhibit 3802, page 9 and 10. When they arrived at the location, Olson got out of the vehicle, retrieved the pistol silencer match sets and grenades, brought them back into the vehicle, and handed the pistol silencer match sets to Cox and Barney. Cox and Barney opened the cases and examined the pistol silencer match sets. Cox examined a grenade. Barney got a phone call, but after he got off the phone, Olson handed Barney a grenade. While Cox and Barney were examining the items, an innocent citizen approached Olson's vehicle and asked him what they were doing. Because the situation was compromised, Cox and Barney were immediately arrested. Both Cox and Barney were wearing body armor at the time they were arrested. In addition, Cox was carrying a firearm on his person, and Barney was carrying 2 firearms on his person. Barney also had $5,000 cash on his person. The same day as the arrest, law enforcement executed federal and state search warrants on the defendants' residences and vehicles, together with the residence and vehicles belonging to the Anderson and Thessing. Some of the items found in Cox's residence include the white dry erase board with KJ&P operations plan, a DVD of a silencer video, CDs regarding converting firearms to fully automatic and silencers, police equipment, gas masks, thumb cuffs, and numerous documents. Some of the items found in Barney's residence where Cox had been staying included cash, computers, phones, a box containing 37mm launcher, projectile components, firearms, ammunition, earpieces, tactical vest with CS canisters, ballistic vest, box containing 2 pulled pins, and 2 unattached spoon handles from practice grenades, and numerous documents. In his truck, Barney had phones identified as yellow phones and a notepad with a list of red, yellow, and green phone numbers. Barney and Cox's red phones were seized from their persons at the time of arrest. Forensic examination of the computers used by Cox and Barney revealed internet searches for the ammonium nitrate bomb in Tannerite. A Google Map search for Alaska Judge P. McConaughey in a document listing 17 acts of war, hard copies of which were found in Cox's residence and the trailer. Text in Cox's iPhone included text about security detailed, police duty belts, machine guns, and hornet's nest. Exhibit 792, Cox's iPhone also had a note titled Ideas to Do, which included a number of items such as a hit list. Exhibit 794-800. Law enforcement also searched Barney's trailer where Cox had been storing some of his belongings since mid-February 2011. In the trailer there were 2 37mm launchers, 4 Hornet's Nest anti-personnel rounds, 4 live smoke grenade fuses with bodies, 7 grenade bodies, ammunition, Tannerite, smokeless powder, JB Weld firearms, including .30 caliber Browning with crank-operated firing mechanism and tripod, Sten machine gun, Sten manual, silenced pistol, gas mask, police belt, and tactical scopes. The jury also heard portions of Cox's post-arrest interview. For example, they heard Cox's statement that when he referred to cans and produce in recorded calls and texts that he was referring to freeze-dried food behind his house and not silencers and pineapple grenades. Exhibit 41-11. During his post-arrest interview, Cox denied knowing what a hornet's nest was. Exhibit 41-12. Cox also said that he didn't recall tasking Vernon and Olson to try and obtain pineapple bodies when they went to Anchorage. Throughout the post-arrest interview, Cox said that grenades scare him and they're not something I would feel comfortable in my possession. Exhibit 4301, 4305, Cox did admit that he had talked about going down south once his family was safe, coming back and waging guerrilla warfare. Exhibit 4303, when asked about the trailer, Cox said he didn't know if it was Barney's trailer and would be only be speculating regarding where Cox and Barney had parked it earlier that day. Exhibit 4401. As to the trial, defendant Cox stands convicted of counts 1, conspiracy to possess unregistered silencers and destructive devices in violation of 18 U.S.C. section 371, 2, possession of unregistered destructive devices in violation of 26 U.S.C. Section 5861D and 5871. 3. Possession of unregistered silencer in violation of 26 U.S.C. Section 5861D and 5871. 4. Possession of unregistered machine gun in violation of 26 U.S.C. Section 5861D and 5871. 5. Illegal possession of a machine gun in violation of 18 U.S.C. Section 9220 and 924A2. 6. Making of a silencer in violation of 26 U.S.C. Section 5861F and 5871. 10. Possession of unregistered destructive devices in violation of 26 U.S.C. 5861D and 5871. 12. Conspiracy to murder officers and employees of the United States in violation of 18 U.S.C. Section 117 and 1114. And 16. Solicitation of others to engage in the murder of an officer of the United States in violation of 18 U.S.C. Section 373 of the third superseding indictment. Cox was acquitted of 18 U.S.C. Section 924C, charges set forth in counts 7 and 15. Defendant Barney was convicted of counts 1 and 9 and acquitted of counts 2, 8, 11, and 13. The jury hung as to Barney on count 12, conspiracy to murder. Federal officials. The court declared a mistrial as to count 12 against Barney, and the government subsequently moved to dismiss count 12 against Barney, which the court granted. Defendant Vernon was convicted of counts 1 and 12 and acquitted of count 14. Vernon's sentencing is set for January 7, 2013, the day before the present matter. Barney's sentencing occurred in September 2012. 3. Guideline applications. The PSR calculated 2 sets of offense levels, one for Cox's conviction of counts 1, 2, 3, 4, 5, and 6, and 10, and one for Cox's conviction of counts 12 and 16. The adjusted offense levels for the former is 36, and the adjusted offense level for the latter is 49. The United States agrees with the calculations resulting in both adjusted offense levels because the adjusted offense level for Cox's convictions for counts 12 and 16 drive the applicable guideline range. The United States addresses below only for the calculations for counts 12 and 16. To the extent that Cox objects to the offense level calculation for counts 1, 2, 3, 4, 5, 6, 10, the United States is prepared to respond to those objections at the sentencing hearing. A. Base level offense. The PSR found that the defendant's conduct for counts 12 and 16 has a base level offense of 33 under USSG 2A15A PSR 141. The base offense level is not contested by the parties. B. Victim-related adjustment official victim USSG 3A1.2b. The PSR correctly found that the defendant is subject to a 6-level enhancement under USSG 3A12b PSR 142. Cox objects to this enhancement because the status of the intended victims as to counts 12 and 16 are already taken into account in the base offense level and amounts to impermissible double counting. These arguments not only contradict the plain language of the guidelines but also previously have been rejected by courts applying both USSG 2A1.5 and 3A1.2. The base offense level of 33 under USSG 2A1.5 applies for a conviction under a number of statutes, including 18 U.S.C. 373 and 1117. A conviction under 18 U.S.C. and 373 does not necessarily involve a victim who is a federal officer or employee. Yet the base offense level of 33 would still apply. There is nothing in the plain language of USSG 2A1.5 indicating that it only applies to crimes against federal officers or employees. Under the guideline, after the base offense level is calculated in Chapter 2, adjustments are applied as set forth in Chapter 3. USSG 3A1.2 provides in the relevant part. If 1, the victim was A, government officer or employee, B, a former government officer or employee, or C, a member of the immediate. Okay, I'm going to stop on the top of page 31. Stopping on the top of page 31. All right, starting with page 31 on the United States Sentencing Memorandum. Member of the immediate family of a person described in subdivision A or B, and the offense of conviction was motivated by such status, increased by 3 levels. If subsection A1 and 2 apply and the applicable Chapter 2 guideline is from Chapter 2, Part A, offenses against the person, increased by 6 levels. Application Note 2, non-applicability in case incorporation of factor in Chapter 2 provides, do not apply this adjustment if the offense guideline specifically incorporates this factor. The only offense guiding in Chapter 2 that specifically incorporates this factor is 2A2.4, obstructing or impeding officers. The sixth-level enhancement under USSG 3A1.2b is warranted because the victims were government officers and employees. The offenses of conviction were motivated by their status, and the applicable Chapter 2 guideline 2A1.5 falls within Part A. Moreover, Application Note 2 indicates that the adjustment applies here because 2A1.5 does not specifically incorporate this factor. The interpretation is consistent with the case law applying these guideline sections. See in terrorist bombings of U.S. embassies in East Africa, 552 F.3D 93 151-55 2D Circuit 2008. Upholding application of base offense level under 2A1.5 plus enhancements under 3A1.1, 3A1.2, 3A1.4, 3B1.1, and 3C1.1, and rejecting arguments that the enhancements were double counting and were expressly accounted for in the offenses of conviction. United States v. Hale, 448 F.3D 971 981 998-89, 7th Circuit 2006, affirming sentence where guidelines application included base offense level under 2A1.5 and enhancements under 3A1.2, 3A1.4, and 3C1.1. United States v. Talley, 164 F.3D 989 1003-04. 6th Circuit 1999, holding the official victim enhancement under 3A1.2 does not constitute double counting even though the underlying offense was soliciting the murder of a federal agent in violation of 18 U.S.C. and 1114 because the base offense level under 2A1.5 does not account for victim being a government official. Citing United States v. Fan, 41 F.3D 1218 8th Circuit 1994. And United States v. Woody, 55 F.3D 1257 1274, 7th Circuit 1995. Thus, the enhancement applies here. C. Aggravating role, USSG 3B1.1. The PSR correctly found that the defendant is subject to an aggravating role adjustments of 4 levels based on his leadership role in directing Anderson to develop a target list, surveillance of targets, directing Vernon to travel to the Anchorage for grenades, directing Barney to unload the Bradway shed, along with directing Thessing and Brockman during the security detail at KJ&P. PSR 143, Cox objects to the application of this adjustment. Under USSG 3B11A, a 4-level adjustment is warranted if the defendant was an organizer or leader and the criminal activity involved 5 or more participants or otherwise extensive. The evidence at trial establishes that Cox was the direct leader of virtually every activity presented at trial. Without his direction, no security detail would have occurred or been necessary. Barney led the detail at Cox's direction. The individuals to be protected by the security detail were Cox, Cox's wife, and Judge Bartell. Exhibit 148, dry erase board, showing security team directions. The notes from the security team briefing show that they had an extensive plan, all circulating around Cox. Exhibit 153, page 3, notes from Cox's residence. Exhibit 203, page 8, notes from Barney's residence. Exhibit 446, page 10, notes from Vernon's residence. At one of the pre-security briefings held by Cox at his house, Cox told the security team members that they needed to be guys who've come to terms with the fact that if somebody shows up at the TV station because it's an hour long and it's live to try to tell Judge Bartle or Marty, you might have to kill him. Exhibit 2-03, 49-50. The testimony at trial by Gary Brockman and Coleman Barney establishes that there were at least 4 individuals outside KJ&P performing the various security functions. Barney testified at his bail hearing that there were probably 5 people with him on the security detail. 52-02, Ken Thessing, while inside KJ&P with Cox's wife and Judge Bartle during the interview, was still part of the security detail that night. Thessing was there to protect Cox, Cox's wife, and Judge Bartell. Thessing was outside for at least part of the time because the photo of Vernon and Brockman that night was found on Thessing's computer. Exhibit 811, trial testimony of AST, Eamon Dunford, and Gary Brockman because Thessing was part of the security team that night. There were at least 5 participants. Based on this alone, a 4-level enhancement is appropriate. However, numerous other facts listed in the PSR at paragraph 143 concerning Cox's direction at Anderson, Barney, and others also warrant application of an aggravating role adjustment. For example, Cox led the 241 conversation. He used Barney and Vernon's homes as hideouts while he strategized about next steps to take. He held numerous meetings at various locations to organize Barney, Thessing, and Lonnie and Karen Vernon. He directed Anderson to compile personal information about federal officers and employees, and he directed Vernon to purchase grenades, which Cox, Barney, and Vernon planned to use on government officers and employees. The evidence at trial, particularly the recordings, clearly established Cox's leadership role, warranting the 4-level adjustment. D. Adjustment for use of body armor in crime of violence, USSG 3B1.5. The PSR correctly found that the defendant is subject to a 4-level upward adjustment because he used body armor during the commission of the offenses, which were crimes of violence, PSR 144. Cox objects to application of this adjustment. The court found the enhancement applicable to Coleman Barney. Given that finding, there was no reason not to increase Cox's offense level by 4 levels for his use of body armor during the offenses. Count 12 charged Cox with conspiracy to murder federal officers and employees between August 2009 and March 10, 2011. Cox wore body armor during the commission of and in preparation for Count 12, which is a crime of violence. On March 10, 2011, Cox and Barney were arrested wearing body armor and carrying 2 loaded guns while at a legal weapons sale where they were examining a silencer and hand grenade. The weapons they had on their persons at the time and they sought to purchase that day were to further the conspiracy to murder. Cox wore the body armor not only on March 10, 2011, but also when he went to Alaska State Trooper R.W.'s home and while he went to Bradway Road Shed with Barney to move his weapons from the shed to Barney's property on February 21, 2011. The weapons footnote. There was a testimony at trial that Cox always wore his body armor whenever he left Barney's house after he moved in on February 19, 2011. The weapons they moved from the Bradway Road shed were weapons to further conspiracy to murder. In addition, Barney and Vernon wore body armor during the KJ&P security detail on November the 23rd, 2010. Barney and Vernon wore the body armor during the 11/23/2010 security detail where they expected law enforcement to show up and had detailed plans for how to engage in force and fire with law enforcement, as directed by Cox. After the warrant was issued for Cox on February 14, 2011, Cox and Barney expected law enforcement would come to arrest Cox. Then, when he knew he was going to go to an illegal weapons deal, he wore the body armor. He wore it for protection from gunfire, not only from law enforcement, but also from Bill Fulton and Aaron Bennett, based on Barney and Cox's stated beliefs that Bill Fulton and Aaron Bennett were dangerous. As set forth in Application Note 1, use means active employment in a manner to protect the person from gunfire. At a 2-level enhancement applies where the offense involved the use of body armor. In this situation where Vernon and Barney were wearing body armor during the November 23, 2010 security detail. But here a 4-level enhancement is warranted instead of a 2-level enhancement because the defendant himself was wearing body armor on March 10, 2011 and other occasions. See United States v. Haynes 582 F.3D 686 711 7th Circuit 2009. Subsection A applies when the offense involved use of body armor. For example, when a co-defendant used body armor. Subsection B applies when the defendant himself used body armor. Because Cox himself used the body armor during the commission of and in preparation for the conspiracy to murder, a 4-level enhancement is warranted. In Haynes, the defendant objected to application of the enhancement because he claimed that he wore body armor to make their targets believe they were legitimate police officers engaged in legitimate law enforcement. The 7th Circuit rejected the defendant's argument. The court upheld the district's court application of the 4-level enhancement. The court drew the reasonable inference that the body armor was being used for its primary purpose, for protection. The fact that the body armor may have been used to identify the defendant officers as legitimate Chicago cops engaged in a lawful police activity doesn't make the enhancement inappropriate. See also United States v. Barrett 522 F.3D 724 728 8th Circuit 2009. The ability of body armor to serve dual purposes does not make 3B1.5 inapplicable, where the facts show one purpose should be to protect the wearer from gunfire. In Barrett, the defendant claimed that he simply wore a bulletproof vest while attending a party with his friends, 522 F.3D at 727. The court concluded that the enhancement applied because the defendant wore the vest while distributing meth to his friends and while threatening his friends with a gun, and because the vest provided personal security when he shot one of his friends. The defendant's fashion statement did double duty as protective shield in case others also carried firearms and were equally disposed to use them. ID at 727-28, the court held that the vest served its intended purpose, even though shots were not fired at the defendant. In an unpublished decision, the 10th Circuit Court of Appeals pointed out that this guideline enhancement does not require that the body armor be used in connection with the drug trafficking offense or crime of violence, and upheld the application of the enhancement. United States v. Chambers, 2008, WL 622807, Star 4, 10th Circuit, 2008. Here, Cox's main purpose for wearing body armor after 2/14/2011 was for protection from gunfire. Thus, the 4-level enhancement applies. E. Adjustment of obstruction of justice, USSG 3C1.1. The PSR correctly found that the defendant is subject to a 2-level adjustment for obstruction of justice as a result of Cox's perjurious testimony at trial, PSR 125-145. In his objections to the draft PSR, Cox objected to his adjustment. However, given Cox's trial testimony, application of this adjustment is clearly appropriate. Here, the court, who had the best position possible to view Cox's outlandish version of events, had a front row seat to Cox's clear attempts to manipulate the jury, observed and heard his continued blame-shifting, denial of responsibility, and the falsehoods he elected to tell again and again. There are numerous examples of Cox's false testimony on material matters at trial. Cox's false testimony was necessarily rejected when the jury convicted Cox of counts 1, 2, 3, 4, 5, 6, 10, 12, and 16. Below are some examples of Cox's willful false testimony. Cox's testimony regarding the names on the list found at Anderson's residence and Anderson's role in the conspiracy was as follows. A. That he did not tell Anderson to put those names down. 6/5/12, page 50. B. That he did not tell anyone to put together a target list. 6/5/12, page 51. C. That he didn't tell Anderson to create a list. 6/5/12, page 106 and 7. D. That he wanted to build relationships with law enforcement. 6/5/12, page 106 and 107. E. That he never had a TSA employee on a hit list. 6/5/12, page 49. F. That he never formed a plan to kill TS or TB. 6/5/12, page 49 and 50. TB is Trina Bootcamp. There's no way that Schaeffer Cox was planning to kill any of these people, much less Trina Bootcamp. G. That he didn't give the names of WW or NC to Anderson. 6/5/12, page 126, 6/6/12, page 114, 6/6/12, page 77, 79, 82. H. That he didn't know where the names on the list came from. 6/6/12, page 114. I. That he didn't make any plans to attack government employees. 6/5/12, page 92. J. That he didn't want to kill anybody. 6/5/12, page 126. K. That he never asked Anderson to do surveillance. 6/5/12, page 56. L. That he wanted to see Anderson because Cox was leaving, not to get the list. 6/5/12, page 112. M. That he didn't have any interest in the list and didn't ask Anderson for the list. 6/6/12, page 113. N. That the reference to hit list found on his iPhone refers to songs. They were going to record an album and call it a hit list. 6/5/12, page 117, 119. O. That he didn't give names to Anderson. 6/6/12, page 170. P. That he didn't ask Anderson to find out where WW lived or to do surveillance, and that he didn't say that she might get a bullet through her windshield. That Wendy Williams is the OCS lady who were targeting Schaeffer Cox's children. He didn't have a plan to kill her, but he was very upset that OCS was coming after his children, as anybody would be. 6/6/12, page 75. That he didn't ask Anderson to look for federal marshals. 6/6/12, page 77. Number 2, Cox's testimony regarding Alaska State Trooper's home address was as follows. That he wanted Trooper BB's home address to visit him about the OCS matter and get his help. 6/5/12, page 51 through 52. B. That he considers a social change agent establishing friendly relationships with law enforcement, with local law enforcement, such as by going to Trooper's home. 6/4/12, page 168 through 169. Okay, we'll stop here on the top of page 41. Stopping on the top of page 41. All right, picking up at the top of page 41. C. That he went to Trooper Ronwall's house because he wanted his help and warned Trooper Ronwall about Bill Fulton. 6/5/12, page 18. 6/6/12, page 112. D. That he didn't do surveillance of Trooper Ronwall's house. 6/5/12, page 56. E. That he only talked to Anderson once about Trooper BB's and Trooper Ron Wall's address, 6612, page 142. F, that he didn't threaten Trooper Ron Wall, 6612, page 4849. G, that the only reason he had Trooper MJ's personal information was to know which jail to go to bail out his friend, 6612, page 71 through 72, despite recorded conversation where Cox said, here's the guy we've been having problems with. 3. Cox's testimony regarding internet searches he did on Barney's computer was that he was only looking for pictures, not planning to murder. Trooper BB, Judge MM, DA, AS 6512, page 147, but Exhibit 779 is a Google map search for Judge MM, not an image search. 4. Cox's testimony regarding 241. A, that Olson relayed the 241 plan to Cox on February 6, 2011, and Cox's response was, that's not good, and nothing would come from that. 6512, page 74 and 76. B, that Olson asked Cox to bring up 241 at the February 12th meeting, 6512, page 94. C, that on February 19th, Olson kept pushing for 241, and Cox kept saying, no, we can't do that. 6512, page 102. D, that he was talking Olson out of 241 and condemning the idea. 6612, page 110. E, that 241 was Olson's idea but came from Fulton, 6612, page 106 and 107. F, that he talked about 241 because the best way to identify bad ideas is to talk about them, 6612, page 147. G, that 241 was a bad idea, 6612, page 148. H, that everyone was against Olson on 241, 6612, page 149. I, that he condemned the plan to kill public officials, 6612, page 150. 5. Cox's testimony regarding Fulton, that he sent people out for armed security detail at KJNP on November 23, 2010, because he was instilled with a very real fear that if I kept trying to pull a Gandhi, Fulton would kill me. 6512, page 44. Hold on, I lost my place here. Oh, okay. B, that he wore body armor 24/7 because he was afraid of Fulton, 6512, page 47. C, that he didn't want to see Fulton at the militia summit, 6512, page 60. That Benedict Arnold Fulton wanted to kick off a fight and use Cox's state court case as a catalyst and reason to kick off the fight, 6512, page 74 through 76. 6612, page 147. E, that when Cox appeared in front of Judge J.K. and told her about people who would rather kill her, that he was referring to Benedict Arnold Bill Fulton, and warning the judge about Benedict Arnold Bill Fulton, 6512, page 84, 6612, page 110. F, that Fulton was going to kill Cox if Cox didn't get on board with Benedict Arnold Bill Fulton's plans to kill judges, 6512, page 84. G, that he wasn't going to appear for his February 14, 2011 hearing because he was convinced that Benedict Arnold Bill Fulton was going to slit his throat, 6512, page 90. H, that he told other militia members not to risk showing up at court with Benedict Arnold Bill Fulton out there, 6512, page 95. I, that he had moral obligation not to go to court because that's going to set Benedict Arnold Bill Fulton off and Fulton's going to hurt people, 6512, page 98. J, that he didn't show up for the February 14th court hearing because he thought Benedict Arnold Bill Fulton was going to kill other people, 6612, page 115. K, that he called Trooper Ron Wall and told him to look out for Benedict Arnold Bill Fulton, 6612, page 115. L, that his plans was to leave and find a place where Benedict Arnold Bill Fulton and the feds wouldn't bother him, 6512, page 146. M, that he continued to interact with Benedict Arnold Bill Fulton because he had a duty to try to influence Fulton, 6612, page 135. N, that for KJNP he gave directions not to shoot unless life is in danger, such as if Fulton jumps out and starts blazing away, 6512, page 196. O, that he fled to prevent Benedict Arnold Bill Fulton from killing local law enforcement, 6512, page 199. P, that his concern at KJNP was that Benedict Arnold Bill Fulton was going to kill him, 6512, page 204. Q, that he was carrying a firearm the night of KJ&P in violation of his pretrial conditions, but he was more scared of Benedict Arnold Bill Fulton than he was of violating his conditions, and didn't want to follow those orders if it meant not being able to shoot back if he had a run-in with Benedict Arnold Bill Fulton. 6-5-12, page 210. R. That he told Trooper R.L., Trooper Ron Wall, and AUSA Steve S.C. About his meeting with Benedict Arnold Bill Fulton in June of 2010. He told them he was afraid of Benedict Arnold Bill Fulton and told them that they needed to be afraid of Benedict Arnold Bill Fulton. 6-6-12, page 7 and 8. 6. Cox's testimony regarding March 10, 2011 transaction. A. That he thought the 310 meeting was to meet the trucker, that he didn't learn that the other items Benedict Arnold Bill Fulton was selling would be a part of the meeting until he got out into Olson's truck. 6-5-12, page 128 and 29. B. That he put gloves on in the truck because he didn't want fingerprints on anything that's going in possession of Bill Fulton. 6-5-12, page 131. 6. He thought the purchase from Fulton was going to be legal. 6-6-12, page 114. That the silencers was represented as legal. 6-6-12, page 152. 6-6-12, page 98 and 104. That upon arrest he said he could stop Fulton. 6-6-12, page 136. 7. Cox's testimony regarding grenades. A. That he had grenade bodies just because they're cool. 6-5-12, page 10 and 11. And that he wanted them for fun. 6-6-12, page 114. B. That he was looking for pineapple grenades because he thought a grenade toss would be a fun activity with training fuses. 6-5-12, page 66. C. That he didn't arrange to get grenades from Olson on 3-1-11. 6-5-12, page 123 and 24. D. That he never made arrangements to have real grenades. 6-5-12, page 123 and 24. E. That he didn't really want 8-second fuses and powder that burns like he said on the recording. That he was not going to make explosives and that was just macho talk. 6-6-12, page 83 and 84. F. That he was using grenades for fun. 6-6-12, page 85. G. That the JB Weld in the trailer was not with the grenade body. 6-6-12, page 86. H. That he never agreed to buy grenades. Never ordered real grenades, never told Olson that he wanted those grenades. 6-6-12, page 97-98, 102. I. That he wasn't interested in grenades. 6-6-12, page 105-106. 8. Cox's testimony regarding 37mm launchers. A. That he had them for his tree business, for sailing and golf. 6-5-12, page 110 through 112. 9. Cox's testimony regarding the silencer was as follows. A. That he built it because it was cool. 6-5-12, page 10 and 11. B. That the silencer was for foxes getting in his chicken shed. 6-6-12, page 138. C. That the silencer DVD found in his home wouldn't work for him. 6-5-12, page 10 and 11. 6-6-12, page 112. 6-6-12, page 92. D. That the other DVDs found in his home, conversion manuals, must have been given to him or belonged to people living in the house, or that they moved out and he didn't go through them. 6-6-12, page 113, 6-6-12, page 94. 10. Cox's testimony regarding the Sten machine gun was as follows. A. That he made the Sten himself, including the parts, starting when he was 16 years old. 6-5-12, page 8 and 10. B. That the Sten didn't work for him. It was just made for display. 6-5-12, page 8 and 10. 6-6-12, page 112. 6-6-12, page 65. 6-6-12, page 76. C. That based on a conversation with an ATF agent, he thought it was okay to have his unregistered silencer and machine gun. 6-6-12, page 136 and 37. D. That neither the machine gun nor the silencer were going to be used to kill people. 6-6-12, page 139. E. That he didn't own any weapons that were illegal. 6-6-12, page 83. 11. Cox's testimony was that he had a police duty belt because it's good holster for a Glock. 6-5-12, page 8. Cox's testimony was that the militia is a good thing to have around every spring when the ice dams up in the Tanana and the floods to Salcha. 6-4-12, page 171. 13. Cox's testimony was that he did not represent himself to be an attorney when he was on the phone with Trooper MJ. 6-5-12, page 58. 14. Cox's testimony was that he did not threaten Trooper TS, that he told Trooper TS, referring to the people versus the government, that we've got you outmanned and outgunned and we could probably have everybody dead in one night. But what good would that do? 6-5-12, page 88. The recording of the interaction reflects that Cox told Trooper TS, We've got you guys outmanned and outgunned, and we could probably have you guys all dead in one night. Emphasis, page 40, going to page 49. Emphasis added. Cox edition of What Good Would That Do is not heard on the recording. Example, Exhibit 927. 15. Cox's testimony was the only time he would use a weapon on somebody if he had absolutely had to, and there was no other possible option to avoid conflict. 6612, page 69. 16. Cox's testimony was that handcuffs were just a cool addition to Ranger uniforms. 6612, page 69. Cox's false testimony contradicted virtually all the physical evidence introduced against him. In that respect, Cox lied to the jury with respect to the following. As to his homemade silencer, he didn't know the law. As to the list, it was Mike Anderson's idea. The silencer DVD would not work on Cox's laptop. The Sten did not fire fully automatic for him, along with he was misled by ATF and FBI rigged the test enabling it to fire in full automatic. Cox's own statements about the Sten, where he admitted it to being fully automatic, contradict this claim, as does Anderson's testimony. The JB Weld was not located where investigators said it was located, in Barney's trailer. The CDs with the full auto conversion manual, silencer instructions, and explosive instructions were not his, but were somebody else's spam left in his home. The internet searches for ammonium nitrate bombs were for fun. The silencer grenade deal on March 10, 2011 was Olson's fault. He didn't know what a hornet's nest was. 241 was blamed on $300,000 hoard Gerald J.R. Olson. And then Cox added to it, saying the idea came from Benedict Arnold, Bill Fulton. Cox's testimony was clearly over the threshold necessary for finding of perjury. Here there's no innocent mistake or accident, but a clear attempt at manipulating the jury and this court. The commission of perjury is of obvious relevance to the extent of punishment, because it reflects on a defendant's criminal history and her willingness to accept the commands of law and authority of the court, and her character in general. United States versus Dunningen, 507 U.S. 8794, 1993. Perjury is false testimony concerning a material matter with the willful intent to provide false testimony rather than as a result of confusion, mistake, or faulty memory. I.d. material testimony is that which, if believed, would tend to... Footnote 8. It is clear from his testimony at trial that Cox is simply incapable of telling the truth, and his lies were calculatingly telling, as they were directed towards specific elements of the crimes which, if believed, may have exonerated him. In several respects, his lying is sociopathic. Page 51. If believed, would tend to influence or affect the issue under determination. USSG 3C1.1, Application Note 6. An obstruction enhancement is mandatory once the proper supporting factual finding is made. United States versus Luca 183 F.3D 1018 1023 9th Circuit 1999. United States versus Anchetta 38 F.3D 1114 11117 1-18 9th Circuit 1994. False testimony before the court can provide a basis for an obstruction enhancement. See United States versus Sherwood 98 F.3D 402 415 9th Circuit 1996, upholding 3C1 enhancement based on the suppression hearing testimony. Cox, like Barney, provided false affidavits with the court while they can be used as a basis for obstruction. See United States versus Hernandez-Ramirez 254 F.3D 841 843 44 9th Circuit 2001, upholding 3C1 enhancement based on false financial affidavit. United States versus Tidwell 191 F.3D 976 982 9th Circuit 1999, upholding 3C1.1 enhancement where the defendant willfully created affidavits with the expectation that they would mislead the court. See also United States versus Munez 101 Fed approximately 216 217 9th Circuit 2004, upholding 3C1.1 enhancement where in a sworn affidavit in connection with a motion to suppress, defendant committed perjury pertaining to alleged threats made to her by an investigating officer. Cox's trial testimony was clear, transparent, and blatant attempt to perjure himself in the hopes of an acquittal. Clearly, the jury saw through this attempt, convicting Cox of every charge save for the 924C charges concerning the carrying of firearms. F. Acceptance of responsibility. The pre-sentence report correctly found that the defendant is not entitled to a reduction for acceptance of responsibility under USSG 3E1.1 PSR 152. Cox claimed partial acceptance of responsibility in his objections to the draft pre-sentence report regarding PSR 127, claiming possession of the Sten machine gun, the silencer, and the grenade launchers and the Hornet's Nest cartridges, and responsibility for same. It is not clear whether Cox maintains this objection regarding no reduction of acceptance of responsibility as to counts 12 and 16 in PSR 152. Cox's actions with others during trial and in opposing the facts of the pre-sentence report, combined with his continued claims of innocence, establish that Cox has not demonstrated acceptance of responsibility for the offenses. It should be clear to this court that it has before in a manipulative, conning, and self-aggrandizing individual with severe sociopathic tendencies. Cox lies easily and often, and while on the stand wove as a defense a fanciful tale, which the jury ignored and was thoroughly discredited by his own words and actions, about a vast government conspiracy composed of a hit team, government informants, and others. When confronted with evidence found in his home, Cox denied knowledge of the existence of the items or that they would not work. He blamed unknown other individuals for leaving CDs full of files ranging from fully automatic weapons, conversions, manuals to how to pick locks. A CD on making homemade silencers wouldn't work on his laptop. The grenades and silencers were $300,000 hoard J.R. Olson's fault. The Sten machine gun would not fire fully automatic for him, and if it did, he was misled by the ATF. This was Mike Anderson's idea. He didn't know the law about possessing silencers. Cox's lies to Agent Sutherland, some of which were played at trial and testified to him at trial as just as revealing. Point. The domestic violence charges were an attempt at character assassination. Point. Cans and produce were references to dried food. Point. He was not aware of a hornet's nest and sting ball was. Point. He didn't recall asking Vernon and $300,000 hoard Gerald J.R. Olson to get pineapples. He would only be speculating as to where he left Barney's trailer that morning. Point. He denied knowing where anyone lived except his friends. Point. He wouldn't possess explosive devices because he was afraid of them and never planned to possess grenades. Point. His Twitter account was a general communication tool and not for a specific purpose. Point. He had not been in contact with Mike Anderson for a long time. Point. He had not agreed to barter the C93 and the full auto lower trigger group to Olson for a silenced pistol. Point. He only wanted silenced pistol because it was cool. Point. Seeing Mike Anderson on March 7, 2011 was not getting the list. Cox's trial testimony in the face of evidence against him vastly outweighs any conceivable benefits he seeks, and as argued and shown here, amounts of obstruction of justice. His plea to the jury upon conviction, but they held evidence from you, illustrates the depth of his denial. As set forth in his objections to the PSR, Cox continues to deny that he directed Anderson to add TB to the list, or that he made threats regarding TB and WW. Cox denials in his objection squarely contradict testimony of numerous witnesses at trial and recordings and physical evidence introduced at trial. In addition, Cox sent a letter from jail during the summer of 2012 alleging that the government manufactured a case against him and that the criminal charges that were brought by Mann are lies. Exhibit Cox letter together with Fairbanks Daily News minor article. It is obvious that Cox continues to refuse to accept responsibility. The final pre-sentence report is correct in not awarding Cox a 2-point reduction for acceptance of responsibility. G. Criminal history category computation. There is no dispute that Cox's criminal history category is category 2. Application of 18 U.S.C. 3553A. In addition to the guidelines, the following sentencing factors set forth in 18 U.S.C. 3553A apply: the nature and circumstances of the offense and history and characteristics of the defendant, the need for the sentence to reflect the seriousness of the offense, afford deterrence, protect the public from further crimes, and provide the defendant training and treatment. The kinds of sentences available, the established guidelines, sentencing ranges, any pertinent guidelines, policy statements. 6. The need to avoid unwarranted sentence disparity between defendants and similar records convicted of similar crimes. And 7. The need to provide restitution to victims of the offense. 18 U.S.C. 3553A1 through 7. Each sentencing factor is addressed in turn. Nature and circumstances of the offense and history and characteristics of the defendant. Number 1. History and characteristics of the defendant. Cox's history and background are characterized by a correspondence school education, a scattered work history primarily circulating around self-employment in outside home repair, landscape, and labor trades. It is of no real surprise given the investigation that Cox's scholastic and professional paths were those of his own choosing. Up until his arrest, Cox chose to increasingly ignore, disregard, and thwart the state's legal system, again through his own choices, by failing to appear for his misdemeanor weapons charge or by claiming that the assault charges filed against him were part of a character assassination scheme orchestrated by the government. It is abundantly clear that Cox himself views himself above the law and that he lives by his own set of rules which he expected others to abide by. His conduct with members of the militia is controlling, his speech is self-aggrandizing, he fails to accept responsibility for anything or any of his actions, from his weapons possession to striking and choking his spouse. His testimony at trial was utterly perjurious, primarily because there is no history of Schaeffer Cox ever accepting responsibility for his own actions. 2. The instant offenses. The fact of the instant offense are well known to the court through the trial of the case and Cox's own testimony. The offenses involve the following serious charges: conspiracy to murder federal officials. Point, solicitation to commit crime of violence, murder. Point, conspiracy to possess silencers and hand grenades, unregistered. Point, possession of a machine gun and a silencer, unregistered. Point, possession of hand grenades, unregistered destructive devices. Page 57. Need for sentence to reflect seriousness of the offense, afford deterrence, protect the public, and rehabilitate the defendant. The sentence must reflect the seriousness of the offense, promote general respect for the law, and provide just punishment. In addition, the sentence must be sufficient to adequately deter criminal conduct, both for the defendant and the general community. Cox promoted himself as the leader of a militia, a leader of the Second Amendment Task Force, and the de facto leader of the so-called Liberty Bell Network. He also organized and promoted flyers challenging the legitimacy of the Alaska court system and the Alaska Bar Association. Claiming both entities were under criminal investigation, he urged those interested to attend his meetings to overturn judgments and recover compensation. Each of these entities, taken alone, was directed to or towards supplanting or challenging government. Taken together, they formed a political movement with Cox as the indisputable leader. He would have it no other way. The crimes of conspiracy to commit murder, solicitation to commit crimes of violence, murder, and the weapons offenses proven by the government are significant, serious, and danger to the public. Cox and his associates possessed a veritable arsenal of tactical firearms and ammunition, including body armor and tactical scopes for their assault rifles. They made attempts at training and amassed enough OC and CS gas in the form of grenade type or grenade launcher rounds to incapacitate a small police force. More than 40 rounds of the stuff. Why so much gas was purchased was something that the investigation never revealed. What it did reveal, though, was Cox's willingness to urge his men to use it, being so bold and unconcerned with the public that he, for his own narcissistic reasons, believed heavily armed, body-armored, attired security details to protect him. But for bad weather, one of these details would have appeared in downtown Fairbanks with the instruction to kill plainclothes agents. At KJ&P, the security detail did manifest itself, with at least 5 members, all armed with tactical weapons, and with a minimum, Barney and Vernon wearing body armor. Cox's inability, and indeed continued inability, to see the danger to the public of his actions speaks volumes as to his understanding or concerns about his actions. The same holds true for the convictions of counts 12 and 16. Cox professes absolute innocence with respect to these charges. The evidence is, however, overwhelming with respect to Cox's expressed intentions to kill. Like most sociopathic personalities, Cox's attempts to distinguish his actions by blame-shifting, qualifications, or other guilt avoidance mechanisms. The fact remains that a jury found him guilty beyond a reasonable doubt of these extremely serious acts, which were part and parcel of Cox's political movement against the government, both state and federal. For Cox to take such steps speaks volumes as to his lack of empathy for the public or concern to a heavily armed, untrained group of men who open fire in public area for his own protection, whether in downtown Fairbanks or at KJ&P. It is just another manifestation of Cox holding his own sense of self-importance higher than that of the public or law enforcement. The irony is Cox could have avoided the entire spectacle and kept his men and the public safe by doing one simple thing: staying home. Once again, his ego and his story got in the way. compiling personal information about government employees combined with his arsenal of weapons and his own recorded words and killing demonstrate the extreme danger Cox was to the public. As to the final factor, the government's view is that Cox is beyond rehabilitation. The simple truth is he believes man's law is of no application to him. This type of belief, akin to subscription to a particular religion or political belief, cannot be remedied. Indeed, after the conviction, Cox sent a letter from Schaeffer, Exhibit A. In the letter, Cox calls the case against him manufactured, and the federal government a godless, corrupt federal government. He further states that, I know these events are from the Lord. They are just too bizarre to be explained any other way. Finally, he asks, please pray that God bring out the truth in this case so that I can be reunited with my family quickly. These are not the words of a remorseful man. Page 60C, kinds of sentences available. Given the defendant's position on the sentencing guideline scale, there are not other types of sentences available aside from the significant imprisonment. Cox's offense level is 6 levels higher than the highest level contemplated by the Sentencing Commission. An offense of level 43 renders a guideline range of life. Here, Cox's offense level of 49 also results in an advisory range of life imprisonment. D. Sentencing ranges available. The guidelines are not advisory but mandatory. United States v. Booker 543 U.S. 220-205, 2005. And the sentencing court may not simply presume that the guideline range is reasonable. Nelson v. United States 555 U.S. 350, 52, 2009. Rita v. United States 551 U.S. 338, 351, 2007. However, the sentencing court must still carefully and correctly calculate the guideline range, and this remains the starting point for any sentencing determination. United States v. Ameline 409 F.3D 1073 186 Ninth Circuit 2005. E. Pertinent policy statements. There are 2 policy statements pertinent here: weapons and dangerous instrumentalities under USSG 5K2.6 and public welfare under USSG 5K2.14. The top of page 61. F. Need to avoid sentencing disparity. The sentence sought takes into account the full range of offense conduct performed by Cox during the course of this investigation, case, and trial. Cox's co-conspirator Coleman Barney benefited from a hung jury as to count 12, and Barney was far less instrumental in terms of leadership as to these offenses. Barney's sentence of 5 years should be no bar to the court's consideration of Cox's sentence, particularly given the different offenses of conviction. Cox's other co-conspirator Vernon, who faces sentencing the day before Cox, was in many ways on his own track with respect to his own actions. Vernon was clearly a team player in Cox's militia and was anxious to acquire additional weaponry for the militia. He was, as seen by the evidence and his plea, just as keen and anxious to follow through with his plans to murder Chief Judge Beastline and members of his family. Vernon is facing a binding sentence range of 262 to 327 months, a range of 21 to 27 years. His spouse and co-defendant in case 28, Karen Vernon, in facing an advisory sentencing range of 188 to 235 months. Both of these sentences, due to the defendant's ages, are essentially life sentences for both. The government's recommendation of 35 years for Schaeffer Cox is based on the totality of the offense conduct. The history and characteristics of the defendant, together with the statutory maximum sentences for the offenses of conviction, which provide for terms of life, 20 years, 10 and 5 years, respectively, for the counts of conviction. Cox's actions and his leadership role justify a significantly higher sentence than the Vernon sentences. As leader of the Alaska Peacemaker Militia, among other titles, Cox would have taken his lumps in state court, accepted responsibility for his acts, and urged peace. Cox could have gone Gandhi, as he testified about, but that was simply lip service to fill in the time up to when the militia amounts enough strength to murder. In the end, Cox would have simply told his men to go home to their families and their lives. That never happened. It was the one thought that never entered into his mind. G. Fine, restitution, forfeiture. While it does appear that Cox does not have the ability to pay a fine, Cox possessed a significant amount of cash and precious metals of an unknown amount. Given his clear propensity to lie, his claims of poverty are likely overblown. Restitution is not an issue in this case. As to forfeiture, There is a non-opposed motion for forfeiture of the hand grenade part, silencer attached to a .22 Walther Sten machine gun, 37mm launcher, Hornet's Nest anti-personnel round at docket 462. The court entered a preliminary order of forfeiture at docket 468 and a final order of forfeiture at docket 534. Page 63, Victim Impact. The PSR includes 2 victim impact statements. The letters provide the court with real and personal information as to the impact Cox's actions had and continue to have, both on officials targeted by Cox and their family members. The sentence sought here will ensure Cox will remain incarcerated for an extensive period of time, thus nullifying the threat he posed to the victims in this case. Conclusion. The court has before it a defendant who, after more than a month of trial, stands convicted of conspiracy to murder federal officials, solicitation of murder, conspiracy to possess unregistered silencers and destructive devices, and possession of unregistered silencers, machine guns, and hand grenades. His guideline range for these offenses, along with the criminal history category of 2, is half a dozen levels higher than the top level of guideline range 43, level 43. In order to simply attain a sentence of life at level 43, Cox would have to convince the court to downward depart 6 levels. The United States recognizes that a sentence of 35 years is a significant sentence. It is no less significant than the crimes Cox stands convicted of committing. At sentencing, the court will strive to strike a balance between the rehabilitation and the safety of the public, among other things. Schaeffer Cox is not, in the government's view, a candidate for rehabilitation. Cox has shown this court his ability to lie and deceive for his agenda, and his ability to lead others through the lies, deceit, and misrepresentation. In the end, Cox would be happy for his troops to do his bidding while he remained comfortably behind giving orders. The court also has before it a defendant whom the government case has demonstrated is without remorse. Cox attempted to manipulate witnesses who testified against him, witness TB, and has manipulated others to his own ends. Cox is contemptuous of his state's and his country's legal system. He possesses a clear disrespect for all law and cares not for the individual rights of others when their rights clash with his own. Cox is of the belief that his actions transcend law. Cox also speaks easily of planning to kill and the act of killing without hesitation as a means of justifying an end. Of his targets, he held no sympathy nor compassion, despite one being a longtime family friend. Of others whom he didn't know, they were to be hanged as wind chimes of liberty. Heads were to be sent in boxes, or children killed as collateral damage. Any armament available, from the hand grenades to machine guns and devices to silence them, were in the offing. He directed and led members of this conspiracy in the direction of killing, who to kill and when the circumstances would be right. The killing was to be justified by political reasons, or as retribution simply because the targets were public servants doing their jobs as judges, clerks of court, state child welfare workers, Alaska State Troopers, U.S. Marshals, or other federal officers. It is clear, page 65, that the term of imprisonment will have no rehabilitative nor reformative effect on Cox. The crimes for which he stands convicted are as serious as they come, and the penalties just as harsh. While Cox is just shy of 30 years of age, his actions demonstrate a clear commitment to form his own style of government through the use of force, intimidation, and murder. He actively sought to recruit others in this cause and proselytized to others outside of Alaska that they should follow his model. He ultimately deviated from the cause and used the threat of his own private army to challenge and threaten law enforcement and the judiciary. There is, understandably, a fine line between what is pure speech and what is actionable conduct. In this case, Cox leapt across that line in seeking explosives and unregistered weapons, while conversationally and easily articulating an intent to kill, while threatening law enforcement and that they were outmanned and outgunned and would be dead in one night, while soliciting others to kill for him. Because of this, Cox's own actions and how he has elected to respond to them over the last several years has demonstrated that a lengthy sentence is the only way of protecting the public and its officials from a delusionally dangerous man who, instead of advocating peace, advocated the use of the gun. Schaeffer Cox is a clear danger to society. A sentence of 35 years satisfies the statutory goals of sentencing, which at their core provide for recognition of the seriousness of the offense, and just as importantly, provide for the protection of the public. Respectfully submitted, the 2nd day of January 2013 in Anchorage, Alaska. The people's signature, the traitors to the United States of America, signed Karen L. Loeffler, United States Attorney of the Corporate United States of America. Serpent, Stephen E. Scrocky, son of Belial, Assistant United States Attorney of the Corporate United States of America. Traitor, daughter of Belial, Jezebel herself, Yvonne Lamoureux, Assistant U.S. Attorney of the Corporate United States of America. That's the end of the United States Sentencing Memorandum against Schaeffer Cox. Let me go take a shower as I clean all the dirt that I feel dirty reading this.